the indictment. So Mr. Glover is charged in 24 DCCR 0232 with unlawful possession of a firearm by felon. And the indictment alleges that he was previously convicted of um, endangering a child July 13th of 2005, which was a state jail felony. And so Mr. Kindler has filed saying that some of the recent case law having to do with what underlying offense is charged would make this not an appropriate predicate for unlawful possession of a firearm by a felon. So specifically, the Hembry case was cited in the motion. I have also gone back. The Hembry case deals with the possession of a controlled substance. So obviously, it's not exact, but it does set out some of the parameters and the fact that there are cases that are not going to be considered if certain criteria met as unlawful or as predicates for someone not being able to possess a firearm. I also looked at US v. Williams. It's a 2024 case. It goes through a little more information on what the judge should do in order to determine make the determination that we're talking about. And the determination, from what I can tell, really boils down to whether or not the defendant is a quote dangerous person, whether the underlying offense had some form of dangerousness. Obviously, some of those are easy if it's a murder or an ag robbery or an ag assault. Here we have an endangering a child. So the question, in my opinion, and I'll let you guys both argue, is whether or not that offense by itself would be considered dangerous and make the defendant a dangerous person. Also, before we go forward, is there any other criminal history that Mr. Glover has that's not listed in the indictment?
I would defer to the city.
There is a federal conviction for felon in possession of a firearm that is based on the same predicate under the same child endangerment.
Okay.
I know of no other felonies that he has. I know of no other felony convictions. There's a couple misdemeanors, but I don't think he has any other felony convictions.
Are any of those misdemeanors what I can take into consideration under this case law any criminal history, including misdemeanors or anything? And so I would like to know what those
I
are.
believe there's a unlawfully carrying a weapon that's from 1998 or 99, Your Honor.
Okay.
And I can look that up real quick if you need me to.
I do. That would be great because so that whatever finding I make, I can make sure and put whatever I need to on the record.
Okay. We'd have to.
It's just, yeah, let me look that up real quick and then.
I filed a motion for jury's elect punishment, by the way.
Okay, thank you.
There's a DPS report that you get for bond conditions. Is that something that would be relevant, Your Honor?
She wouldn't have it in this case. It's from 23.
Yeah. God bless you.
Your Honor, I'm showing unlawfully carrying a weapon convicted in 1999. I believe there's an evading on foot in the year 2000.
Is that a conviction?
It's a conviction.
It's a class B then, I believe.
Think so. He didn't. His sentence was 90 days, and that's a class B, so I don't think that would qualify.
Well, all of it can be taken into consideration, is what the reason I'm asking. So even though it is not a felony, every bit of criminal history can be taken into consideration for me to consider dangerousness. Thank you.
And then a 2003 DWI conviction that is actually, I think, in conjunction with that endangering a child. And then as far as state history from 2003 up until this arrest, I don't see anything, Your Honor. The federal conviction, I believe, is in 2009. And again, I think that's the extent of his history.
I see an assault,
It did show up at the front.
Maybe I missed it.
from,
Shows summary in the summary.
it was dismissed.
Yeah, there it is, Judge. That's from 1997. It was dismissed.
See, and on the list that I get, it doesn't say what the disposition was.
Thank you.
That, no, I appreciate that. Okay, so we've got the endangering a child and an unlawful carrying a weapon and an evading, and then a DWI, and then a prior felon in possession of a firearm in the federal system.
Yes, Your Honor.
So the way I read this really is that the burden is on the defense to prove that he's not dangerous, or that these are not dangerous offenses that would do that. So, Mr. Kimler,
I might briefly have him sworn, answer a few questions.
would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole, or in this trial, if we go to trial, will be the truth, the whole truth, and nothing but the truth? Thank you. Go ahead.
You state your full name. Mr. Glover, you understand you have a prior conviction for endangering a child, is that right?
I do.
What were the circumstances of that case? What happened, the factual circumstances?
I was drinking that night. My girlfriend at the time had a daughter on her lap. I was pulled over. I was put out of the police department.
Okay, so was this a DWI with a child in the
Yeah, I
car?
believe so.
There was no wreck, there was no high speed, except
Just
nothing.
traffic stop.
So the endangerment was the fact that you're operating a motor vehicle while intoxicated, is that
Yeah.
right? As far as your dangerousness now and your criminal history, are you employed? What do you do?
I'm employed. Paper Felon.
Sorry.
He's employed with Gabriel Funeral Home. What do you do in that capacity?
Funeral home assistant.
And you have responsibility for what? What do you do at the funeral home?
Well, I transport, dress casket, I prep funeral service, transport, first calls.
And you pick up bodies, is that right?
Yes, I do, yeah.
You do that from crime scenes?
No, the county medical examiner.
Okay, from the medical examiner. You don't go to crime scenes.
No,
It's a responsible position, right? You work.
it is.
Haven't had any problems with that? When's the last time you're in trouble? Like, other than this case,
2023,
right?
over 20 years ago.
Okay. Pass witness.
I am trying now, unless you guys have it handy, to see if there's a way for the clerk to go back and find the probable cause affidavit from that underlying.
And Your Honor, I've looked at it and I'll pull it up for report, but I'll tell you that he's accurate as to what it alleges.
Well, the indictment alleges excessive speed and some other things, so
I think
know-
it was, I'll pull it up for the court,
Okay.
but I remember it, essentially someone called in a reckless driver, swerving
Okay.
speed.
Just, you've had your opportunity. Let us look up what I need to look up. You'll have an opportunity through your attorney in a minute. Ma'am? Okay. It sounds like Mr. Nichols can get it for me, maybe. No, she didn't have it. We can't get to it.
Sorry about the late date for filing this motion, Your Honor, but I was doing the research over the weekend and kind of came across this case.
It's all right.
Thought I needed to do.
Yeah, it's definitely
do
something that we all need to be probably more aware of. Yeah, I know the Hambre case is on, they've at least filed a petition for
Okay.
review, but I haven't, it did not show if it had been granted
For
for
en banc?
discretionary,
Non bond or for PD or for?
PD for cert, it looked like,
Okay.
from what I could tell, but I may be wrong, but something is still out there
Out there.
potentially on it.
Judge, here's the probable cause affidavit.
Thanks.
Endangering child case.
You don't have any objection to me
No,
reading
ma'am,
this?
no, don't you?
You want to take a look at it?
Hi.
Yeah, and it doesn't, I don't know, the indictment alleges excessive speed, but what this really comes down to is looks like there was an EMS unit that was behind Mr. Glover, and they're the ones who called it in. And stated,
So,
sir, just stop. I already told you to stop until you were asked a question. Let us keep our train of thought and figure this out. And if we need to hear from you, then Mr. Kimmler will ask you at the certain time the right question. Please don't make me ask you again, okay? So this is just what the probable cause says. It says that the Gold Star EMS unit was behind a 78 Chevy, struck a curb several times, failed to maintain a single lane. Dispatcher advised that EMS unit felt that the vehicle was going to wreck if it was not stopped. They stopped the vehicle. The officer stopped the vehicle 3600 block of Highway 69. Driver, Mr. Glover, they could smell a strong smell of alcoholic beverage, had slurred speech and could not say his ABCs nor do a finger count test, conducted standard field sobriety test, failed all tests. The vehicle that Glover was driving was occupied by a front seat passenger who was carrying an 8-month-old baby girl in her lap. And he was placed under arrest, refused to provide a specimen, and then charged with this.
And then we have the conviction for the underlying BWI as well. I think is what
I believe so, yes. So there was a conviction for the endangering a child as well as the underlying BWI. So I guess, let me ask, Mr. Nichols, what's the state's position?
Just so that we're upfront honest, Judge, my read of what the court said in Hembry was that it is the government's burden to prove the history and tradition. Well, that's actually a different issue than the dangerousness part.
Right.
But as far as dangerousness, we look at what his criminal history is. None of those stick out as what are typically considered aggravated or violent offenses. There is a weapons possession conviction for a misdemeanor prior to this. I think there's a element of danger in reckless driving while under the influence, however, especially with the child unsecured in the front seat. I do think that is dangerous. There is certainly some time since that's occurred that would tend to mitigate that dangerousness. And I won't pretend that this is these are fresh cases, but that is his history and that's what he has done and been convicted of.
Mr. Kimmler?
I suppose if the question is obviously endangering a child, the statute itself that he was convicted of says it's danger. So that's one thing. But if you look at the underlying circumstances of that, I think that was filed at a time when we didn't have the DWI child passenger statute. I may be wrong about that. But it probably is now, that probably would have indicted as a DWI child passenger, not the endangering of the child. So I don't know. As far as the dangerousness is, if it's an analysis of what he is at present, I think that he's demonstrated he's gainfully employed at Gabriel Funeral Home. Bears like a
Yeah, well, I guess so. I don't want to. Let me stop you because the dangerousness that I can tell, or the dangerous people under that Williams case, it has really not to do with anything other than their criminal history. So it's not what they're doing now, what they were doing then, good person, bad person, how long it's been. It's what those offenses were and whether or not he would be considered then a dangerous person because of that criminal history.
Basically, the inference on the criminal history alone, they're not present circumstances.
That's the way I read it.
Okay.
Yeah. And it goes on to say, and this is a 2024 Sixth Circuit case, this Williams case. It just goes into this one was the underlying criminal history was, I think, much different. We didn't have the issue of the possession of a controlled substance. And it just goes into a little more detail of what to look for than the Hembry case does. The Hembry case really was very specific about drugs and those types of cases, and that a possession is one thing, a possession with intent to distribute could be considered dangerous, whereas a plain possession wouldn't. And that's kind of where it is.
I'll leave it in a school zone, perhaps too.
Right. But none of those apply. So, I mean, and here's the thing, I want to do the right thing under the law. I don't.
Judge,
disagree, I guess, with really both of you that this isn't an egregious underlying offense. But I also, it is literally in the indictment, you know, uses the word danger, you know, that he intentionally, knowingly, recklessly engaged in conduct that placed the child under 15 in imminent danger of death or bodily injury by operating. So I do think, you know, just by the nature of that itself would be that. I don't, but Mr. Nichols, you had something else. I'm sorry.
I was just going to let the colonel, I don't have that Williams case in front of me. It's not what I'd looked at. I focused more on Hembry, and I think it was Diaz was a similar case or one they cited too. And Hembry gets into this historical analog of
The analog, right?
And that puts the basis or the burden on the government to show this analog. And frankly, I don't know that I've had time this morning to develop the facts necessary to do that.
Well, then potentially instead of granting or denying the motion, maybe we reset it for a week just for this hearing. Any information that you have and want to present with regard to that, we can do, and that way and then I'll make a ruling, and either it's back on the trial docket quickly or I grant it and it's gone.
We could just reset it for a trial docket, make the ruling and pick a jury. If that's, I mean, I'm not asking to, for delay if the court wants to try to get it tried. I mean, we can reset it for today is what I'm saying. I don't know that we'd have to reset it once you make your ruling for another trial docket, just set it on the next trial docket maybe, or.
We need to have a hearing. So I have to reset it to a hearing date. I want everybody to know. I mean, obviously, especially, I would think Mr. Glover, if I'm going to,
Can I have 1 second?
yeah, if I'm going to grant your motion, then obviously he wants to know that sooner than 3 months from now. So if I'm not, then we need to get it on the trial docket.
He wants to make the right decision.
Thoughts?
I feel like we'd probably end up arguing it again at a later date if we move forward right now.
That would
makes
probably
sense.
what? No.
I don't. My understanding of what's required by the government in this historical analogy is it's going to require a little bit more from me than what I have this morning.
Right.
So I want to get it right. I want us to get it right the first time.
I agree. All right, so let's do this. I'm going to, and it's not something, once you have that done, we can just maybe set it on a regular docket at 11 or something
Sure.
in a couple of weeks. And
That should be plenty of time, Judge. I think I could do it before the end of this week. I just need more than half a morning.
sure. Okay, well, then what I'll do in just a second is I'll go out and let the jury know. Mr. Eckhart is in jury. Mr. Coleman, they had a jury seated this morning over in Orange, so he is actually in trial. So that case is not going to be able to go. So what I'll do is let me just reset this to next Monday, and we'll all get together again. And if y'all want, we'll plan on probably doing it towards the end of the docket if there's whenever y'all have time. I'm sure everybody's usually here on a Monday anyway. So you need to be back next Monday at 9 o'clock. And I'll make that decision, and we'll know one way or the other if we're going right back on the trial docket. We'll figure out a good day, or if it's going to get granted.
Thank you, Your Honor.
Okay, thanks, Sean. Good morning. You're Kevin Boyd.
Yes, ma'am.
And will your client waive the formal reading of the indictment?
Yes, Judge.
This pulled up. All right, so Mr. Boyd, in cause number 26, DCCR 0227, the state has elected to proceed on a lesser included offense of a driving while intoxicated second. And that's from November 26th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes.
And because you did what they charged you with?
Yes.
And then the indictment further alleges that you were previously convicted of driving while intoxicated February 9th of 1984. And is that true or not true?
Yeah.
True or not true?
True.
And I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Mitchell? The papers on the tablet, did you go over those with Mr. Mitchell?
Yes.
Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, you.
And it looks like the agreement that you've reached is for a 1-year term in the county jail, but that would be probated. You'd be on probation for 2 years. You would be required to have the ignition interlock device for that entire probation period,
Yes.
as well as paying a $4,000 fine. And in addition to that, there is no waiver of the state DWI super fine. That's something with you and the state. Do you understand?
Yes.
And then Judge, just for your,
State would request that certified.
All right, thank you.
and right now he has the handheld blower. He does not have a vehicle that he's driving. So
Yeah,
he,
he does have that.
Okay, so if you're not driving,
Yes.
you cannot drive any vehicle
Right.
unless it has that auto ignition interlock device.
Yes.
If you're not driving, then part of your probation would be to keep that handheld the entire time as
Yes,
well.
Your
All right. And you're a US citizen, correct?
Yes.
State tenders number 1.
no Judge.
It's admitted. Any evidence that Mr. Boyd is not competent?
No Judge.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the Class A misdemeanor, driving while intoxicated second. Sentence you in accordance with your agreement to a term of a year in the Jefferson County Jail, but probate that. You'll be on probation for 2 years. You're ordered to pay the $4,000 fine and so with the DWI second, it's 3 days. So there's a requirement of 3 days in the Jefferson County Jail by law. Are you working?
Not currently.
So what I'm going to do then, Mr. Boyd, is order that you serve those 3 days starting this weekend. So you will report to the Jefferson County Jail Friday at 6 p.m. You're going to serve 3 days, so you'll get out on Monday. That way you get it all taken care of at one time. It's very important that you are on time, be at our jail at 6 o'clock, no later. Also, it's obviously very important that you show up not intoxicated or anything like that. Some people think it's a great idea to show up and, sleep it off. Don't do that. If you're late, if you don't show up, that's a violation of your probation and you'll be right back in court. Do you understand?
Yes.
Also, I'm ordering that, again, the state's super fee is not waived. The state has requested that, and so it will not be waived. I'm going to hand you the trial court certification that shows that this was an agreement that I followed, and so you have waived your right to appeal.
Yeah.
It's coming. Anything else I need to, I think I said it all. Yeah, make sure you go, if you don't have the attachment. And Mr. Mitchell, you can either email today the attachment, or if you want to handwrite it on something, what you looked at, you can do that as well. But we need it today before we close out the case.
That's fine. I can call McKenzie real quick and have her send it over.
Perfect. If they'll email it to Ms. Holmes, that'd be great. All right, here's that trial court certification. If you'll just have a seat here in the courtroom, probation's going to call you up to her desk when she's ready to go over your paperwork, and she's sitting right behind you. So watch for her to call you up, okay? And again, make sure 6 o'clock this Friday, which is the 20. What's Friday?
Does he need anything to get in, Judge?
I don't think so.
Okay.
It'll be there.
Okay.
All right. Thank you.
Judge, I'm gonna take him out in the hallway for just a second and I'll go right back in.
Okay. Collier. So this is 24 DCCR 0751. Mr. Kimler, I don't see that you have filed anything that I requested get filed before today.
I didn't understand why I have to file a bill. I mean, it was an illegal sentence. I mean, she never should have received the sentence. They wouldn't, the court have the power to vacate the sentence.
No, I don't without a motion.
I did. I filed a motion to vacate the sentence. Yes.
I don't see it.
Really, that's how it's come to question.
It's not.
I think there was a
It's
motion.
not a quash. That's not,
There
and
was-
that's why I sent you, and I talked to Mr. Florence, and you said that you were going to talk to Mr. Florence. And we did all the research, and I've done all the work for you, which is very
All
frustrating
the work I filed the writ.
before today. And I mean, literally 3 days after court, I handed you on a silver platter, here's what you need to file. You emailed back that you would talk to Mr. Florence if you had any questions and get it filed. So today, what can happen is if you would like to make an oral motion for me to vacate all of the proceedings, I would entertain that oral motion.
Yes, I think I filed a written motion to vacate along with the beginning of the case.
To vacate or to quash?
But maybe, I thought it should be to vacate. I don't know, maybe to quash the MTRP. I don't know.
It's a motion to quash. Would you like to file an oral motion to?
A routine courtroom hearing suddenly takes a dramatic turn when a convicted felon challenges the very foundation of the gun charge against him. The defense argues that a past child endangerment conviction may no longer legally qualify as the predicate offense needed for the firearm charge. Instead of rushing to judgment, the judge carefully reviews recent case law, examines the defendant's criminal history, and openly admits that the law is still evolving. Rather than making a decision without enough evidence, the judge postpones the hearing to ensure the ruling is legally correct. It's a powerful reminder that in court, one legal argument can completely change the course of a criminal case, proving that justice depends not only on facts, but also on how the law is interpreted. This courtroom moment shows why every detail matters when someone's future is on the line.